item number 15, docket number 357202, People versus Kevin Thomas McCollum.
Good morning, Your Honors. May it please this honorable court, Alona Sharon on behalf of the appellant, Kevin McCollum. I've been here enough times and before, Your Honors, to know that you're all very familiar with the very lengthy brief. I am just going to highlight maybe 2 or 3 of what I think are the strongest points for Mr. McCollum, and then I'll take my seat. I would reserve maybe 2 or 3 minutes for rebuttal. And hopefully, if I'm brief enough, there'll be more than that for rebuttal.
Okay.
I think for Mr. McCollum, what is the strongest issue is trial counsel's decision to show the entire care house video to the jury, which I think is clearly in violation of People versus Douglas. And the prosecution.
It doesn't have a per se rule that you can never, if anytime you show a video like that.
Well, I think Douglas holds that the care house video is inadmissible. There is no hearsay exception that would allow the child's statements to be admissible. I don't think that there is a per se rule, but I think Judge Murray, what the issue turns on is whether or not there's a strategic reason, right, to admit it. And that's where I think trial counsel has a problem, and where the trial court got it wrong, and where the prosecution gets it wrong, right? Because trial counsel can't make a strategic decision based on ignorance of the law. And the one thing that is clear from this record is that Mr. Escobedo wasn't even familiar with or knew the decision of People versus Douglas. Okay, so while he repeated multiple times that he strategized with the client and made this decision with the client, sort of as a way to blame the client for this mistake or this strategic, and I'll put that in quotes, decision. The one thing that he did admit is that he had never read People versus Douglas. He wasn't familiar with the decision. And so discussing that holding with the defendant never came into play, or even considering that holding when making this quote strategic decision. And there is ample case law that's cited in the brief that strategic decisions can't be based on ignorance of the law. That can't be considered strategic. And so
there you go. You took a breath so I can ask him.
you can always interrupt me, Judge
I
You
was
just tell me
waiting.
to shut up and I'll be quiet.
Oh, I won't do that. Let's talk about strategy, right? Because that seemed to be a huge element for the trial court, that trial counsel developed this strategy. And the strategy was, I'm going to let everything in because I want to show that this young victim, alleged victim, was, some people put ideas into her head. And the more I let in about her recanting the sexual assaults, the better my case. And initially, he has an expert who he's retained on behalf of his client. But what happens, it seems to me, is the expert issues an opinion prior to trial. And that opinion doesn't, with some minor inconsistencies or problems, that the pretty much says, no, nobody put this into his head. So for me, and then I'll ask you to explain why this logical tack would be incorrect in terms of analyzing your case. For me, it no longer is a reasonable strategy. Putting aside his ignorance of the law for a second, which I think you really can't, but just for a second, you now have a case where you're going to let an abundance of hearsay evidence in, completely uncontested. In essence, the victim's going to testify 3 times, unchallenged. And your rebuttal, if you will, to that is, there were a couple of things that were asked of this person that maybe shouldn't have. But the jury's sitting there and all they hear is the same story over and over and over. In my opinion, that's a strategy, but it's not a reasonable strategy. Now, what would that be? Is that inaccurate legally, or, excuse me, or how, what would you say in response to that line of thinking?
Sure. So Judge Borello, I love your question, and I think you totally get the argument I'm trying to make in the brief on appeal, because, and I hope I tried to hammer this home in the brief on appeal, is that while
Actually, both of you wrote very good briefs. Both of you. It was very well briefed.
Mr. Miller is a fantastic writer. I'm often jealous of the quality of his briefs, but what I think is very clear from the record of the Ginther hearing and just the trial record itself, okay, is that you have Mr. Escobedo who says, right, this is my strategy of trying to show the evolution, right, of this child's statements over time. But then you have, I believe it's Dr. Thompson, who issues a report prior to trial and then gives testimony that concurs with that report that says, I really didn't have concerns about the Care House video. The child's statements were consistent. The Care House interviewer did pretty much a banged up job on this interview. I didn't have any issues with it. And you have this expert who is retained by the defense who, like Judge Borello, you recognize, says, yeah, her statements were pretty much consistent. There really wasn't any inconsistencies. So how is this a reasonable strategy? And the answer is that it wasn't. And I think what becomes clear, and while, you know, it's always a difficult job for an appellate lawyer, right? Because you don't want to point fingers at a colleague, but I think it's really highly questionable, number one, whether or not trial counsel ever actually closely watched this Care House video prior to trial. Because one of the points that I really try to make in the brief is that even in opening statements, he asked the jury to focus on certain parts that he thought were problematic in this Care House video, and they don't even exist in this Care House video. Not even do they not exist, but they aren't even problems that are pointed out by the defense expert, not in the defense expert report and not in the testimony of the defense expert. So, right, this underlying reason that trial counsel gives for allowing in all these hearsay statements, which I'm not going to restate all my arguments about why they're not really admissible and are they really hearsay statements. I've briefed it to death. I don't need to beat a dead horse. But all of this underlying reason why the strategy for allowing all this in, it's garbage, okay? It makes no sense because when you look at the child's allegations, they are consistent. So is it a reasonable strategy? Is it a strategy that makes sense? Absolutely not. And that's why he's ineffective. And that's why the ruling of the trial court makes zero sense. And
but what happens is, in my opinion, after reading the transcript, or its portions, I didn't read the whole trial, but he's in essence arguing against himself, as you point out, right from the get-go, right from opening statements. He has the jury focus on something they ought not to be focusing on. If you're the defense counsel, if you're the prosecutor, it would be a good place to point the jury to. But in essence, he's arguing, listen, you'll see it. This is what, and then so the big kaboom, if you will, is now comes my expert, right? And that's why those of us who were trial lawyers, you always, you know, I'm going to get you now, but he knows in advance it doesn't exist. So I agree. I don't speak for my two colleagues. He's ineffective. Now let's get to the tough part, right? And of course, the tough part is we're showing of prejudice. And what are your arguments relative to why we should grant your client a new trial because he was actually prejudiced? Sure.
And I think Douglas speaks very clearly. That's not
That's
my.
our Zoom.
Okay. I don't know if that was like the gong telling me to sit down.
No,
We have a book.
He packs heat.
That's great. I'll die. I think Douglas speaks very clearly to that point, and I think you also pointed out is that the result of putting in this Care House video and all of the hearsay statements, right, is that the jury ends up hearing from the child. And it is detailed, right, painfully in my brief in a chart with all the timestamps, something like 18 times the allegations over and over and over again. And every time is unchallenged, not cross-examined. they see demonstrations from her. And in a case, it is a credibility case when you're getting to see and hear a complainant over and over and over again, unchallenged, that will prejudice the defendant. I think Douglas
It was
is,
only the victim testified about.
well, I would respectfully disagree, because I do think you have corroborating testimony from all of the school officials or staff who also repeat hearsay statements from her, from the friend who repeats hearsay statements from her.
I guess I meant in the sense that there was no witnesses.
You mean like eyewitness?
Yeah.
But there weren't in Douglas either, right? That's something that's,
Arguing against you.
oh, okay, right. I would agree with you, Judge Murray. I guess I always assume that you're going to argue with me, not. Right. Yeah, that would be something that is in common with both Mr. McCollum's case and the defendant in Douglas.
Eating again and again and again during the video was a prejudicial fact when, you know, or the only person testifying or anything.
That is, yes, that is correct. And it's not just the hearing, it's the seeing. I mean, if you watch the Carol's video, I know Mr. Miller was kind enough to take care of providing it to the court for me as our appendix, is that it's not just listening to the child, it's also some very effective, I think, demonstrations of how the sexual assault occurred. That is going to prejudice the defendant in a case that is a total credibility contest. And the last thing I want to say, I do just want to briefly touch on the testimony from Dr. Eaton, who is the complainant's father. The prosecution focuses and argues that his testimony does not amount to expert testimony, that it is lay witness testimony. And I think that that is an incorrect position to take. It is very clear from the testimony that the prosecution very much elicited testimony from Dr. Eaton about his professional credentials, his expertise, and that would only be for the purpose of bolstering his opinion in the eyes of the jury.
Otherwise, it's completely irrelevant.
Correct, exactly. Why would you
Who
ask?
cares what he did for a living, unless
Exactly.
you want to smuggle in the fact that he might have a kind of an expert view of this.
Exactly. Thank you, Judge Kelly. Otherwise, that testimony would be wholly irrelevant. And I do think it was very clear that he testified that it was only after his daughter alleged, or after he knew that the daughter was sexually abused, that her behavior became clear to him that it was because she was sexually abused, because children who are sexually abused, or excuse me, experience trauma tend to mimic behavior of ADHD. And so I think, Judge Kelly, you kind of get where I'm coming from. So I will sit down and reserve my remaining time for rebuttal. Thank you. Thank you, Your Honors.
Good morning, Your Honors. Joshua Miller from the Oakland County Prosecutor's Office on behalf of the people. We're asking the court to affirm the trial court's decision denying the request for new trial. To jump right into addressing the defense arguments. People versus Douglas does not control this case, as the defense argues, because it is the opposite of Douglas in this case. In Douglas, the forensic interview was admitted over the defense objection as a prosecution exhibit, and was concededly in Douglas being offered for the truth of the matter asserted. So here we have a Care House video being offered as a defense exhibit, not to prove that it's true, that everything that's said in it is true, but as part of the defense counsel's strategy to show that it was false, effectively that it is anti-hearsay. Now, to address
Anti-hearsay.
anti-hearsay,
Anti-hearsay. That sounds like a new superhero.
or a villain, depending on your
Or
point
a
of view.
villain, correct. But Douglas, I mean, we've all read Douglas and we know what it says. And to some extent, I agree with your, not to some extent, I actually agree with your analysis. But the problem that I have is, why would you, as the defense attorney, let that interview in? And you know it's going to be the victim, unabated, just, you know, and I mean, we watched the video, how that was going to help him, especially, let me stop for a second. Just, here's the thing. Had the defendant gotten an expert opinion that said this interview was so wrong, or so many problems with it, I I cannot, in my professional opinion, resolve the issue of whether this young lady was telling the truth or whether the interviewer was putting ideas into her head. Then I don't have a problem with letting it in. I still would question what the reasonable strategy is, why you would let it in when you can just rely on your expert's opinion. But here, he already knows, right? Trial counsel knows he doesn't have that kind of power in that opinion. So what's the reasonable strategy here for allowing that in?
I think the issue that I took with defense counsel's argument in addressing your earlier question, Judge Burrell, was that there was a lot of focus on the idea of consistency. It was, well, this, if there had been inconsistencies and it had built to that, and the expert had been able to testify that there were inconsistent, but Mr. Escobedo was very clear that he knew that there was generally consistency from beginning to end. The point that he was trying to show was that in a very, very short period of time, the complainant's allegations went from basically bare bones talking to her friend EP saying, I can't remember exactly the phraseology, but
right.
He touched me inappropriately or something, to here we are a mere 2 or 3 days later, and she's at this forensic interview, and it's this lengthy discourse about he did this and he did that. And he's trying to show, okay, how did we get from point A to point B? What happened in between? And it was she's talking to these people, talking to these people, talking to these people. And each time she talks, more details get added. The story keeps evolving. And so he was, as Mr. Escobedo testified at the Ginther hearing, his point, he was looking at the case and saying, okay, I have basically 2 options, assuming that my client doesn't want to plead guilty. My options are take a strategy where I go after the complainant, I attack her credibility, I dig into everything she's saying, and I risk alienating the jury. Or I attack the process. I attack how the story evolved from point A to point B. I attack how the police went about interviewing the defendant and investigating the case. And I lay it all out for the jury and say, does this look reasonable to you? How did we go from basically an innocuous statement to her friend, I guess not an innocuous statement, but a simplistic statement to her friend on the school bus, to 3 days later, we're getting these graphic details. And then immediately everybody assumes that this is what happened. And the police just dive right into it, expecting that, this guy's guilty and we just have to corner him and get him to admit to it. And we're going to put him through this interview where none of the allegations are repeated in graphic detail. And what does he do? He denies, he denies, he denies, he denies. And in Mr. Escobedo's words, forthrightly denies. So it's part of this strategy.
You'd make a good defense lawyer. By the way.
Yeah, you would.
That's a very-
I was thinking,
Very strong argument.
Thank you. So it's part of this overall strategy of attacking the process.
Did the victim's testimony, was it her testimony as detailed?
I think in my opinion, to a large degree it was. She was talking about him using his tongue, touching her in her, she called it her special place. And it's, regardless of whether she's on the video or she's in testifying in front of the jury, it's very graphic. It's very graphic. I will concede that point. The statements made in the Care House video are very graphic. There's no disputing that. But
I had a problem I'm sorry, Judge. I had a problem hearing the video.
okay,
It wasn't the best.
yeah,
Not your fault.
yes, yeah. I would recommend that they get better.
Somehow better for the jury though.
I'm not sure how they made sure that, or what equipment they played.
Here's the thing, is why, I mean, I get the whole strategy, but why couldn't the defense counsel make arguments out using that video? I mean, you could have said, you know, she first made the disclosure to a friend, then it was the school people, then it was the police, then she had a care house interview, and that's why, based on the expert's testimony, she had all these details in her trial testimony. You know, I mean, it's a hard one to overcome that. It was a really bad decision.
Oh,
Yeah, and let's face it, this ineffective is raised, I don't want to say in every single criminal appeal, but a majority of them.
but it
Certainly a
is.
large majority of it. Most of the time, it's Monday morning quarterbacking. And you say that was a strategy, but this seems, you know, to be a big problem. I mean, for all the reasons we're saying, I just can't think of a good reason to have gone down this road.
In the trial court, you know, I mean, she did a you know, job trying to not second guess and all that. You know, reading the transcript and where the expert has some slight critique about what occurred during the care house interview, it's almost like he's struggling to come up with something. You know, I just, and again, you know, I'm usually on, you know, not on the side, but the standards of review and everything else makes it hard to overturn decisions by a trial court, but this is a hard one not to do it. I just don't.
And,
It's
and,
tough.
You want to talk about the prejudice?
and, you know, going to the prejudice, I think the fact that the complainant did testify and was subject to cross-examination, the Supreme Court in, I believe it was Gursky, said, you know, in situations where you have, you know, I'll call it hearsay because that's the phraseology. I still maintain it's not hearsay for the reasons I outlined previously, but when you have statements that are challenged in this way, if the complainant did testify, it takes away a lot of the oomph because she was still subject to cross-examination about her allegations. And yes, it's a credibility contest. No one's disputing that. But you know, when the defense is able to cross-examine her at length, knowing what's in the video, knowing what she's testified to, it takes away the sting, for lack of a better phrase. So unless the court has any other specific questions for
I
me.
have one quick question. Is Marilyn Day's your boss, right?
She is,
You
yes.
go back and you tell her, next time you take these cases, don't send me, you do it. You tell her I'm
Oh.
very disappointed she didn't have the guts to come and argue this.
I'll take that as a compliment to Marilyn, but I wounded Judge Burrow.
You always do an excellent job, counselor. and we
Thank you.
appreciate it.
We both do. We can make a video
Yes.
to demonstrate to other lawyers about how to actually argue in the Court of Appeals for both of you. It's always very, very good.
Thank you. And I'll keep the recording of this in mind when the next time they're talking about giving me a raise. So thank you.
All right, thank you.
Just two comments in response to Mr. Miller. One is regarding the strategy for Mr. Escobedo about that as more details evolve. I would just point out, because I'm not going to repeat myself, in footnotes 11, 12, and 13 of my brief, I really do try to be very clear with citations to the record. Again, admissions by Mr. Escobedo and statements by the expert that there was no evolution. And secondly, in terms of the statement that the child was subject to cross-examination, again, I would reiterate that Mr. Escobedo said very early on in the Ginther hearing that he really had no intention of going very hard at the complainant in terms of cross-examination. And so while the prosecution likes to argue that that might take the sting out of the 90-minute care house video, we know that Mr. Escobedo really didn't challenge the complainant very much at the trial because he thought that that would not play well with the jury. So in terms of whether or not that would take the sting out, I think it really didn't in this matter. So thank you very much, Your Honor. It's always a pleasure.